That's what I'm known for. If
Patient.
anybody laughs, you're going. Give you a chance to talk with your attorneys about what you want to do and the process by which that will happen. You understand that, sir?
I mean, I just don't understand why I can't plead guilty, man. I mean, you can do what you got to do, but I plead guilty. I would like to plead guilty today.
Well, that can't happen. You would waive so that I can get you to a place where you can do that as soon as it's available. Is that what you want me to do?
No, I would like for you to accept my guilty plea.
Pardon?
No, I would like for you to accept.
I'm not. Okay, sir. I'm not taking your plea. Pardon?
I don't know if I can make it. I'm not understanding it.
Today, we're inside Judge Simpson's courtroom, and right away, this defendant looks completely lost, like he woke up in the wrong reality 5 minutes ago. He honestly thinks court works like customer service, where asking nicely means you automatically get your way. To him, rules seem optional, procedures sound negotiable, and the judge is just there to approve whatever he wants. Meanwhile, Judge Simpson stays calm while explaining that none of it works like that, but you can almost feel everyone's patience running thinner by the second. The tension in the room comes from the fact that everyone understands the process, except the one person whose future depends on it most. And this confusion isn't harmless either. There's a massive gap between what this defendant thinks the law allows and what his actual rights are. Instead of slowing down and listening, he keeps doubling down. So now the real question becomes whether this is simple ignorance manipulation or something much worse. And at what point does the court stop entertaining it? Let's get into it.
Just saying 3 to 10 and clearly based off of it, we talk about getting what we're looking for, right? We can send over that medication information and see if we can get something better, but we're better suited in circuit court if we do that. But it's totally up to you. Okay?
Please guilty.
Sorry, Your Honor. Thank you for the court's patience. I just had to relay some information.
That's what I'm known for. If
Patient.
anybody laughs, you're going. No, go ahead.
You are a very patient man, Judge.
Go ahead. Second.
So, Your Honor, today is the date and time set for probable cause conference in this matter. I do understand my client has been deemed competent to stand trial. I've had conversations with him. He tells me that he is prepared to enter a plea today. I've explained to him that that's not something that the court would be able to do at this stage. I've also explained to him that typically we would send this matter up to circuit court so that the sentencing judge will be able to properly enter his plea for him. He says that that's not something that he wishes to do. So I'm kind of at a crossroads at this point, Judge. I don't know.
So, sir, if you're going to enter a plea to these cases, it would have to go to another judge to take that plea, which is the waiver that counsel's talking about. I could not accomplish that today for you.
You can't just
Usually,
plead guilty.
Mr. Gatlin, what we do is once I've made the finding that I made today, we adjourn it out to the next available day, give you a chance to talk with your attorneys about what you want to do and the process by which that will happen. Okay? You understand that, sir?
I mean, I just don't understand why I can't plead guilty, man.
Because if you pled guilty, you'd be pleading to felony charges. Those pleas are taken before a circuit court judge, which is why it would have to be waived and you would have to go up to circuit court.
I mean, you can do what you got to do, but I plead guilty.
Well, let me do this. You've not discussed a waiver with him in detail, have you?
I mean, I have, Your Honor. I've explained to him what the waiver does and how it would send him over to circuit court with a pretrial. I've explained to him his right to the preliminary exam. I suggested that we set it for exam, but...
All right. Sir, you seem like you want to get it moving, and I don't have a problem with that. Do you want to waive so you can go up before the circuit court judge and do what you're going to do, or do you want a preliminary examination to have a hearing on the charges?
I would like to plead guilty today.
Well, that can't happen.
Is this guy genuinely incapable of understanding what's happening? Or is he just refusing to hear anything besides what he wants? The judge and even his own attorney have repeatedly explained that he cannot plead guilty right now, yet he keeps repeating the exact same line over and over. I want to plead guilty. It's like watching someone mash the same broken button, expecting a different result every time. What makes this painful is that the court is actually trying to protect his rights, not take them away. Judges are not required to accept a guilty plea just because a defendant demands it, especially when competency and procedure are still in question. A guilty plea gives up major constitutional rights. So the court has to make sure the defendant fully understands what he's doing and is making a decision voluntarily and intelligently. Right now, he's showing none of that. Instead, the harder he pushes, the more concerned the judge becomes. Persistence doesn't pressure Courtroom. It raises alarms. His attorney is practically throwing out warning signs, and he ignores every single one. At some point, this stops looking like confusion and starts looking like a refusal to deal with reality. And if he keeps going, the only thing he's accomplishing is digging himself into a far worse situation.
Wish to plead guilty, I can get you, you would waive so that I can get you to a place where you could do that as soon as available. Is that what you want me to do?
No, I would like for you to accept my guilty plea.
Pardon?
No, I would like for you to accept.
I'm not, okay, sir, I'm not taking your plea. So your options are, I could set this for preliminary examination, or you can waive the preliminary examination and I will send it to circuit court where they will be more than happy to take your plea. If you don't choose either one of those, I'm adjourning the proceeding, finding good cause to do so. So, sir, what is your choice?
I don't know if I can make one.
Pardon?
I don't know if I can make it. I'm not understanding this.
All right. If there's something you're not understanding, I've got to give you time to talk to your attorney about it. So what I'm going to do is I'm going to give you the fastest date I can possibly give you to come back. Once you've had that, figure out exactly what you're doing. So I'm going to find good cause to adjourn the probable cause conference in this matter. I will adjourn it to my next date is the 9th to October 9th, 2025. 9 a.m. His bond will continue. Thank you.
I'll come and see you. Thank you, Aaron.
Trust me, nobody in that courtroom is confused about the fact that this defendant has no clue what's happening. Everyone realized that the second he started talking. Whether this is genuine confusion or some failed attempt to bully the court into giving him what he wants, neither option helps him. Courts are designed specifically to stop people from steamrolling the process just because they're loud or stubborn. The irony is that by demanding a guilty plea so aggressively, he's proving exactly why the judge can't accept one yet. Courtroom time is limited, expensive, and shared, and behavior like this wastes it fast. While serious cases wait in line, the system gets stuck babysitting someone who refuses to listen. That's part of why the justice system moves so slowly. Judges aren't denying him out of ego or power. They're protecting the integrity of the case and preventing appeals later on. A plea entered incorrectly today can completely destroy a case months down the line. That's why the process forces patience, even when it feels frustratingly slow. Because the reality is simple. A rushed plea today could collapse the entire case tomorrow. So what do you think? Should courts get tougher with defendants like this? Or is patience simply the cost of due process? Let me know below. Thanks for watching, and don't forget to like and subscribe before I'll see you in the next one.